The execution of Charles Vallow is not a family tragedy. There is nothing that you can say about shooting a man as he lay on the ground that you can try to construe in any way to make that a family tragedy.
Well, hey, everybody. Today, the Arizona courtroom becomes Lori Vallow Daybell's final stage act. Now, the question is she going to testify and risk being cross-examined, or will she rest her case without ever taking the stand or putting on any evidence? Remember her opening statement? The evidence will show. Well, it hasn't shown anything. And as Judge Beresky prepares to instruct the jury, and the prosecution prepares to push their final argument forward, the stakes couldn't be higher. And the legal reality that Lori now faces couldn't be higher. Because only one juror could cause a mistrial. Hey, welcome to Profiling Evil, and thanks so much for hitting the like and subscribe button. Make sure you're ringing the bell, that you've got the notifications turned on so you're getting all of our videos. And please consider sharing Profiling Evil with your friends and, of course, all your other contacts. Now, today might likely be the final act in Lori Vallow Daybell's Arizona murder trial. Now, she might be given a chance to say something during the victim process after a conviction that I believe will likely happen. But what we've been watching unfold over the past couple of weeks has been painful at best and disturbing in many, many ways. But the stakes couldn't be higher than right now. Lori's standing at a fork in the road, and the question becomes whether she's going to take the stand and testify or whether she'll rest her case without saying another word. And this is really kind of tragic that she's going through a murder trial without putting on one stitch of evidence. Unless, of course, she thinks all of the time she testified during her questioning of the state's witnesses was her way of testifying. But either way, once the decision is made, we're going to move straight into jury instructions and closing arguments. And I'll tell you right now, this could be a courtroom showdown unlike anything we've seen so far in this wacky case. So let's just kind of talk about a couple of things that are going to happen today. First, Lori Vallow, as a reminder, is charged with conspiracy to commit first-degree murder in the death of her fourth husband, Charles Vallow. Now, he went to police complaining about her, and they just couldn't do anything. Eventually, he was murdered, and now they are doing something. You know, he says that she thinks he was possessed by a spirit named Ned. Now, of course, he says she was receiving spiritual revelations from whatever God it is that she believes in. He pleaded for help, but none came. And a few months later, this guy was shot by Lori's brother, Alex Cox. Now, the state says this wasn't just a family tragedy like Lori has tried to pitch it. This was a calculated execution disguised under divine revelation. So now, before those closing arguments can begin, the judge has to get instruction to the jury, but he can't do it until she says she truly rests. Then he'll explain what the law actually requires for this kind of a conviction. That she intended to assist or promote in the conspiracy to murder somebody, her husband. Now, here's something important, and this is where it really matters for Lori. In Arizona, there has to be a unanimous verdict in order to get a conviction. So that means all 12 jurors must agree, beyond a reasonable doubt, that Lori is guilty of conspiracy to commit murder. If there's just one holdout, one person who isn't convinced, one person who thinks Lori Vallow Daybell is a victim of either a husband that was mean or a justice system that's unfair, this could result in a hung jury, and that panel has to make sure that they come out unanimous. So Lori isn't just playing to the whole group. She might be playing just to one individual, one juror who could tip the scales in her favor, and that would lead to a mistrial. That adds pressure, not just on the state to be airtight in what they're putting on, but on Lori to appear human, credible, sweet, maybe even misunderstood. But this isn't a trial about being misunderstood. This is a trial about murder. And if there's a juror who's out to protect Lori, somebody again believing she's a victim, then things could go down the tubes. So what's the prosecutor likely to argue in the moments that are going to follow this discussion we're having? First, I think we're going to see a powerful closing by the state. And contrary to the feelings that some of you have, I think Trina Kay has methodically built this case. And I expect her to tie it all together with 4 key points. First, she's going to walk the jury through the digital evidence, things like the iCloud messages, where Lori is talking about things that they've got planned, telling Alex, stay close, things are coming to a head. We're going to be like Nephi and pull this thing off. Lori's reference wasn't symbolic. It was a warning. Now, number 2 is the prosecution's likely going to highlight the deceptions that were going on after the fact. Lori's behavior following Charles's death, I think, is going to be really important because it was so bizarre. She was calm, unemotional. She lied about her phone. She left the scene to get snacks for the kids. There was no grief, no concern. Just a manufactured version of events that fell apart when compared to the facts like digital evidence. She didn't even let family members know of this family tragedy she had. Let's just call it like it is. She didn't let them know that her brother murdered Charles Vallow. Now, third, the prosecution has to try to find a way, if they can, to broaden the lens just enough to show a pattern. Lori didn't just lose one person in her life. She lost everybody that got in the way. Charles, Tylee, JJ, Tammy, Alex, perhaps Joe Ryan. In every case, she benefited spiritually, emotionally, and most importantly, financially. And I want to just add, and a sense of power and control. And finally, she'll likely say something like, Lori Vallow didn't need to pull the trigger to be guilty of murder. She only needed to want it done and make sure that it happened. And Alex was her trigger man. But the big question is going to be, will she testify? I mean, she's already doing what most people would never attempt to do. She's representing herself. She's questioning witnesses. She's objecting. She's trying to wear both hats of the defendant and a defense attorney. And you can't be a solid, hard-hitting defense attorney and then be a sweet victim. It just doesn't work well. And today, she's got one last decision to make. Because if she testifies, we can expect something really out of the ordinary. She might try to frame herself as a mother, a spiritual giant of a woman who was misunderstood by the world. She might get emotional. She might lean into scripture. And she might even try to charm the jury. But if she chooses to testify, she's going to open herself up to cross-examination, and that's a war zone she doesn't want to be in. The state's going to be ready to bring out every contradiction, every lie, every moment that Lori slipped. A single misstep under pressure could undo her entire defense. And just go back and think about that Rule 20 motion for just a moment, where, in my opinion, she slipped dramatically, calling it a premeditated murder. Now, if she doesn't testify, she still gets to get up and put on an act. She gets to deliver her own closing argument. And if she does do this, which I expect, we can expect more of the same tone that we've seen throughout the trial. She might suggest that God's with her. Again, whatever God it is that she believes in. and that she was just protecting her family through all of this, that the state doesn't understand spiritual things. But make no mistake, the jury is going to look at the facts, not feelings, I hope. And when Judge Beresky hands down that case to those 12 jurors, Lori's fate is going to rest in their hands. So what's going to happen if the vote isn't unanimous? As I mentioned at the start of the video, if just one juror refuses to convict her, the judge could end up declaring a mistrial. Now that doesn't mean she walks free. She still has the first life sentence, but it means on this case she could be tried again for it. But if the jury is unanimous and the verdict is guilty, Lori Vallow Daybell will move one step closer to being held accountable for Charles Vallow's death. Not just for what happened in Idaho, but now for Arizona. Perhaps even growing beyond that. And then, of course, we have to just accept the fact there could be an outright acquittal, and she could walk from the charges on Charles Vallow, never to be charged again. So I really want to know what you think. Do you think she's going to testify? Will the jury be unanimous in the decision they make? And if in fact she does give a closing argument herself, will it be her last sermon? I've been texting back and forth with Nate Eaton this morning, who's sitting in the courtroom, and I believe he's going to shoot a little video to me a little later today. But this thing is really building up into a fervor. That place is packed as those closing arguments are going to be offered. So let's go in and listen to those closing arguments now. And then when we're done, please put your comments down below. And thanks so much for supporting Profiling Evil. If cult behavior is really intriguing to you, check out my book, Deceived, an investigative memoir of the Zion Society cult. It's a case where I dig into one of the most crazy cult cases in U.S. history and how I broke that cult apart and rescued a bunch of children. I think you'd enjoy it, but most importantly, the book focuses on some additional dynamics like why people join cults, how cults continue to maintain control over seemingly intelligent people, and in some cases, how they get away with murder. Hey, thanks for your support of Profiling Evil. Look for us on Facebook, Instagram, YouTube, and Twitter. And if you like audio podcasts, make sure you're checking out Profiling Evil's audio podcasts on your favorite podcast platform. Go to our website, sign up for the BOLO, and let's get into this trial.
Ladies and gentlemen of the jury, the state of Arizona has the 100% burden of proving that I committed a crime, a grievous crime, conspiracy to commit premeditated murder of my husband, Charles Vallow. The state has the burden of proving to you that this event was not self-defense. In your jury instruction under the instruction, Use of Force and Crime Prevention, the last line reads, if the state fails to carry this burden, then you must find the defendant not guilty. In the law, under your jury instruction titled Justification for Defense of a Third Party, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. Under your jury instruction titled Justification for Self-Defense, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. In your jury instruction, under presumption of innocence, it states, the law does not require the defendant to prove innocence. Every defendant is presumed by law to be innocent. Under the burden of proof, it explains that the state's burden is this. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If, on the other hand, you think there's a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In Arizona, self-defense is defined as not being a crime. So let's look at what we've learned in this trial. In Arizona, self-defense is defined as not being a crime. So let's look at what we've learned in this trial. We learned that a shooting occurred and that 911 was called, that law enforcement was notified. We learned that fire, EMS, and Chandler Police arrived at the scene. We learned that my brother, Alex Cox, came out of the house with his hands up as directed by 911, police in the driveway. We learned that I came up with my daughter Tylee, and we were told to wait by the car until police would speak with us. We learned from Detective Inklin on the stand that we asked for Tylee's medication from the house for her panic attacks, but it was not given to her. We learned that eventually my brother Alex was taken in a police car to the Chandler Police Department uncuffed. We learned in this trial that my daughter Tylee and I were also taken to Chandler Police Department in a police van. We heard from Detective Inklin's testimony that her goal was to make small talk with us. And
the jury will determine what the testimony did or did not show. Go ahead.
that her goal was to make the small talk with us and all the way to the station so she could speak with us separately before we would talk about what actually happened. We learned that all three of us were separated and taken to 3 interview rooms, where we each told police of the events of the day, each from our own perspectives, and answered all questions asked of us. We saw snippets of that interview in the trial here. The state did not show you the entire interview. Most of my police interview is admitted, though, into evidence in this exhibit. It's number 286. And I would encourage you to watch that entire interview when you start your deliberations. It is important. It is important for you to determine for yourselves my demeanor and not listen to anyone else. You can see it with your own eyes and hear it with your own ears. We heard from several witnesses that because this event was almost 6 years ago, that their memories of the events and statements were probably better back then. Well, my police interview happened that very morning, and I told the police the events from my perspective at that time. It is admitted into evidence and will answer many of your questions. You did not see Tylee's interview, but we did learn from Detective Inklin that she did an interview that morning as well. You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent, whom we did not hear from in this trial. The state chose not to show you those interviews.
Object, Your Honor.
Or let you listen to the 911 call.
The jury shall disregard that last statement. Okay, the jury can only consider what was admitted into evidence.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump and, according to his testimony, a 1-inch laceration. We did not see those pictures documenting that injury as well. We learned in this trial that we did not know, the 3 of us, that our interviews were being recorded. We learned that Alex's phone was taken by police and put into an evidence bag, according to Detective Duncan, and that no digital copy of Alex's phone was taken by the Chandler Police Department, even though this is their normal protocol. We learned that Alex's phone was returned to him that same day with no further inquiries. We learned that after my interview and Tylee's interview that we were introduced to a victim's advocate and that gave us further instructions in another room where Tylee and I were reunited. We learned that soon after that, all 3 of us, Alex, Tylee, and myself, were taken in another van and dropped off back at our house. We learned that we were instructed at that time that we could not enter the house yet, that we were directed by law enforcement to take the rental car, since all 3 of our cars were inside the police tape. We were directed to return later in the afternoon when the scene was cleaned up. We learned in this trial that we did as directed and left the house in the rental car close to 12 p.m. We learned that we did not return to the house until contacted by Detective Inkland to return to the house so that Alex could walk the detectives through what they call a walkthrough. We learned that many detectives were present during that walkthrough with Alex. We learned that Detective Duncan was there, Detective Coons was there, Detective Moffett was there, Detective Werther was there, and an officer with a body cam was there. And yet, we were told by Detective Duncan, the case agent on this case, on the stand, that because of some problem, the walkthrough is not recorded. Detective Duncan also informed us that he does not know if any of the people present wrote a report about it. We can infer from Detective Duncan's testimony and the fact that we don't have in evidence any body cam footage of the walkthrough and no reports talking about it, that there are none, even though this would be crucial evidence for you, the jury, to have.
Sustained, the jury should disregard that comment. Again, the jury can only consider evidence that was admitted into testimony. I'm sorry, testimony that was admitted into evidence or exhibits that were admitted into evidence.
The state of Arizona has the obligation to show you evidence to prove that this event was not self-defense, as stated by the only 3 witnesses. So why not show the jury all the evidence that they gathered?
Again, sustained, the jury can only consider the evidence and testimony that was admitted into evidence.
We learned in this trial that Alex fully cooperated with law enforcement. We learned that my daughter Tylee fully cooperated with law enforcement. We learned that I fully cooperated with law enforcement. We learned that law enforcement treated all of us that day kindly and courteously on July 11th, 2019. That law enforcement treated us that day like this was self-defense. We were not given instructions to stay in town. We were not given instructions that we were under investigation of any kind. On July 11th, 2019, we were interviewed by Chandler Police and released with no further instructions. We learned that Chandler Police put out a press release that day on July 11th.
I'll sustain that objection to the extent the jury is to determine what the facts did or did not establish.
Under Arizona law, I had the right to self-defense. Tylee had the right to self-defense. Alex had the right to self-defense. This event was not planned or expected. It was shocking. We learned in this trial that Chandler Police Department neglected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue. We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene. They did not test the gun until over 5 years later. The Chandler Police Department did treat this event just like it was self-defense and a tragic family event. We learned in this trial that Charles and I were obviously having marital problems. Regardless of what was happening in our marriage at the time, on July 11th, this was self-defense. When Tylee came out with the bat to protect me, her mother, Charles did not have to take the bat from Tylee and start swinging. At 62 years old, Charles had a choice that day and could have put the bat down. A 2-minute period changed our lives forever. How are you supposed to choose between 3 people you love? Your husband, your daughter, your brother?
Testifying at this point?
All right, hold on. All right, I'll caution the defendant not to testify about things that were not entered into evidence.
How can you decide for another person if they feel threatened? Why does the state want to blame to someone?
It's a reasonable person standard, not the standard of the person.
I'm sure you'll point that out in rebuttal. I'll allow the argument as that inference. Go ahead.
Why does the state want to blame someone for this tragic event? What evidence did the state show you in this trial that I wanted harm to come to my husband? We learned in this trial that I was praying for my husband. We learned in this trial that even though my husband and I were having marital issues, that we were both trying to do the best things for our son with special needs, JJ. We learned in this trial that I was shocked that Charles had changed his life insurance policy, but I was not angry as the state alleges. In the phone call we heard from the insurance company, we heard that I was disappointed for our children, our grown children, as well as our children still at home, but I was not angry. My husband Charles was providing for our children still at home. I had no motive to change that. We heard a lot in this trial about the Book of Mormon prophet named Nephi. This is the state's evidence to murder over self-defense, and it is utterly ridiculous. We heard from Detective Duncan, who admitted on the stand that he had no idea what I meant in the text message when I said, "We will be like Nephi." In Mormon culture, Nephi signifies strong faith, perseverance, and courage.
All right. That's sustained.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is absurd. This is an attempt by the state to try to retrofit a crime that doesn't exist. This event was not a crime, it was a tragedy. Don't let them turn my family tragedy into a crime. When I'm done speaking to you, the state gets to get up and rebut all that I've told you. They've got to have the last word, so to speak, because it is 100% their burden to prove to you that I committed a crime. And you won't be allowed to hear from me again. So I want you to remember that it is the state's job to prove to you that I committed a crime. And if you have not seen the evidence that leaves you firmly convinced that I have committed this very crime, then the state failed to show you the evidence that you need. Because I did not commit this crime. The only interview the state entered into evidence is mine. So I encourage you to go watch it. I told you just what happened that day, just the way it happened. The state put forth a bunch of evidence in this trial in an effort to make you dislike me, to try to attack my character, so that you would just say guilty no matter what evidence they showed you. But only you get to decide. The state put up witnesses that had zero knowledge of a conspiracy. The state did not show you evidence of an agreement to commit murder. They showed you evidence of a family tragedy, and then they showed you the sad effects of a family torn apart because of that tragedy. That's all.
All right, the state does have the burden, so they have the right to open and close the argument. Do you want to give a rebuttal close? Go ahead.
The execution of Charles Vallow is not a family tragedy. There is nothing that you can say about shooting a man as he lay on the ground that you can try to construe in any way to make that a family tragedy. This case is about the defendant, not Alex Cox. Alex is involved in it because that is her co-conspirator. We are not here to determine his guilt, albeit it is quite obvious. This defendant wants you to just look at one piece, and she wants you to hope that there's only a person who will say, I saw, I heard the conspiracy. But what did you hear in every instruction is that you can look to other evidence to show that. This defendant wants you to forget about her words and pretend that when she told her lover, her soon-to-be husband, we got rid of him, that he changed the life insurance before we got rid of him, that somehow means what? That they killed him. And he changed his life insurance before they killed him. What does that tell you? That tells you motive, and that tells you who did it. This defendant is one of those we because she's writing it. She wants you to pretend that when she is talking about Charles for months, acquiescing and agreeing to her brother killing him, having people tell her that it's wrong, having people know that they're planning for something, that those words don't mean exactly what they are. We got rid of him, this defendant. The state, of course, has the burden, and that's how it should be. But every one of those justification defenses falls short when you look at the conspiracy itself. When they got rid of him, they did it by planning it. There is no reason that Alex Cox came over to this defendant's house with a loaded gun and waited for Charles to come inside, held there by this defendant using the cell phone. That is conspiracy. That is planning. That is premeditated. You can absolutely watch that whole video. That's why the state included that for you. What you're going to see is that Lori Vallow doesn't cry. She is not truthful, as we've gone through. Her timeline is absolutely wrong. She tells the detectives it's quick, it's 12 minutes. She wants you to believe that the police could understand all of this that day. But what did you hear? Is that all the police could tell initially was that the timeline was off. And then they started learning that the physical evidence seemed to be showing that Charles was executed on the floor, but they needed to see if the medical examiner agreed with them 2 days later. And then they needed to pull all those iCloud accounts, phone records, and go through terabytes of data to bring forth these things that you have now learned and hold. They interviewed these people who learned of the defendant's religious beliefs, that she was exalted, that she was celestial being, that she didn't have to repent. Of course she thought she was Nephi. We learned that the physical evidence on Charles and at the scene show us that he was executed. And every single one of those defenses that the defendant has asked you to look at, the state has met its burden. Because even if you somehow believe that Charles actually had that bat and it wasn't staged like the rest of the scene with the shoes and the lack of blood there, that second shot is not justified for self-defense, crime prevention, or third-party defense. Arizona law does not allow you to execute a man on the ground. The defendant wants you to believe she was shocked and surprised by this, and yet she goes wandering around, goes to Burger King, Walgreens, drops off her kid, comes back and jokes about her neighbors. Not one action of a person shocked, surprised. She wants you to feel bad for her daughter, Tylee. You saw her there. You heard from the detectives. She's also not shocked, crying, upset, worried. And you saw Alex. Same demeanor. Why? They've had 47 minutes to work it all out. Go through Charles's phone, figure out what they're going to say. They've talked on the phone twice in this time period. This case relies upon all of the investigation that the police did. That day, when they knew that timeline was wrong, that day when they started to understand that the physical evidence at the scene was staged and wrong and didn't match what the defendant was saying, and then all of the evidence after that, culminating when this defendant told the man that she married later that she was having an affair with, as many times as she wants to say Charles was my husband. She didn't want him as her husband. She wanted Chad Daybell. She wanted that life insurance policy, and yes, she was angry about it. And she said, we got rid of him. That is her confession to you. That is why she is guilty of conspiracy to commit first-degree murder. Thank you.
We'll see you soon at the next crime scene.